Okay, so we used to have clients who'd commit a trespass, they'd get a time served and get out, and then we'd still see them next week, and then they'd get a time served and get out, and then we'd see them next week, and then get a time served and get out. Now what's happening for some is they're getting a PR bond, getting out, unsecured bond, getting out, unsecured bond, getting out, unsecured. So it didn't. I didn't see a big. I keep seeing the same people, and it's just that now they're on bond, and now we can fight the case, and they're getting through this. In other words, they're getting through this system as they normally would anyways, but now they're getting through it without picking up 5, 6, 7, 8 convictions back to back to back to back to back. So what I think is going to happen is the district attorney's office is going to have to start thinking about and making better decisions as to what cases they're going to start prosecuting, and whether or not certain cases are worth it, and whether or not certain cases justify spending taxpayer resources.
Absolutely.
So going on that end about people on bonds, about the role of the judiciary, what do y'all think about pretrial conditions, bond conditions? Let's say for a DWI, what are your thoughts on interlocks? Let's say, and also for assault family members, we hear a lot about the no contacts and magistrate's orders for emergency protection. What are your views and standpoints on those?
Sure. I have a very short answer. I'll go ahead and take this one. The law of the land is that people are presumed innocent unless proven guilty or unless they plead guilty. And it's always been my view that bond conditions are a way to punish people before they're proven guilty or before they're found guilty, etc. For the most part, I oppose bond conditions because what we're doing is we're disregarding the Constitution of the United States, which is innocent unless proven guilty beyond a reasonable doubt. And we're punishing these people. I had a client, just really quick, he was a DWI client, like you say. He was poor. He had to get an interlock installed. But when his blood came back, he was .000. And then the prosecutor was still not satisfied, made him get an interlock while the came back for toxicology. Blood came back, 0 drugs, 0 everything. And this person was a person on food stamps, and it caused a very great hardship for him to put that interlock on for the 4 or 5 months while we waited for blood results. And it really changed his lifestyle. It really did. It put him in a much worse situation. And I fought the judge, and she still ordered the interlock. And I've seen it. I've seen it.
What are y'all's opinions on interlocks and to follow up magistrate's orders for emergency protection and no contacts?
For the most part, and with Armen to a certain degree, I do oppose them, but I also believe that they are also necessary for the two-pronged system that David was talking about, which I do somewhat agree with also, that it is a two-pronged system that's been developed over time. I know it's not written in the Constitution, but it's been developed over time, that it's also a safety function for the community. And if a person calls as saying that they were assaulted, magistrate's order for protection is imposed, I mean, the last thing you want is while they're out of your court, when the alleged victim requested a MOAP and they didn't receive one, and then they end up getting hurt or something worse ends up happening to them. I do believe that you do have to protect them to a certain degree. I'm not in no way saying that they're guilty or anything like that, because they are presumed innocent until they are proven guilty. But at the same time, when it's requested by an accused, for some reason or another, the call was made, the police were involved. We don't know the facts, but if it's requested, I think at the very least we can do that. No contact orders, I think, are a bit much, but MOAPs at the request, if proven up by the alleged victim, I'm in favor of them. I really am.
Complaining witness.
Yeah. Are you magistrate's orders for emergency protection are judges' orders that prohibit certain conduct between a defendant and a complaining witness, and prohibits certain conduct from the defendant from doing or traveling to. Magistrate's orders for emergency protections are the norm. You prefaced it and you asterisked it with magistrate's order for emergency protections when the complaining witness asks for them.
Correct.
But it seems like, I mean, they're the norm, so they get the MOEP before that request is made. What are your thoughts on that?
And I think that's a big problem. I think that, an order of protection is something that it should be requested and they talk to the victim, the alleged victim, and make sure that they want them. What I see happening additionally is that they order these MOEPs, these magistrates order for emergency protection, without even talking to the victim.
Right.
So the DAs will go ahead and on their own request this. Now, what I've seen, good things happen. I've seen judges say, hey, did you talk to the victim? And judges will say, well, yeah, we talked to them and they requested, okay. In that instance, it gets ordered. And I've also seen it the opposite, where they say, no, we haven't talked to them. And it still gets entered, and it shouldn't. And in that instance, it shouldn't. But I've seen them do it anyways, and I think that's wrong. It needs to change. But I've also seen judges do the right thing as well. I've seen judges, now sitting judges on the bench say, well, you haven't talked to them. Why are you requesting this? Which is the right thing to do.